What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today I'm pumped to have my buddy Ian Runkle of the Bailey on. He's been covering Karen Read's second trial every night, doing recaps for hours in depth for the late night owls, or depending on where you're at, probably the perfect time for many. I asked him when he sleeps and he said not very well. I just had to time out our pre-video discussion because I really want to get his take on, as an overall feel of the trial. It seems like all reports are saying the Commonwealth is almost done with their case in chief. What have they actually proven from his perspective? And regardless of if we agree with the Commonwealth's case or anything like that, we want to look at it as lawyers. What have they actually proven? And then what reasonable doubts has the defense pointed out, drummed up, highlighted, or started that process, planting the seeds in the jurors' minds before they go into their case in chief? So everybody hit that like button. We've got a couple days off court, but we're still talking Karen Read. So let's welcome in Ian Runkle. All right, Ian. So
hey, how are you doing?
I'm doing great. And I appreciate you jumping on and joining me here to talk through some of this, because we have a second trial that I told you before that reports are they only have one witness left. That's what people are reporting. It could obviously be wrong. Reports have been wrong in the past. There could be a couple more witnesses, but everything we've heard is the Commonwealth is going to be done this week. Their case chief's going to be done. And I think there's only three. That's everything I've heard from multiple sources in the courtroom reporting on it, is that they're going to be done this week. I don't know if it's true, right? But I think there's 3 days, because you said something about Thursday. I don't know if it's a half day or no court. Monday is no court. So, 3 or 4 days this week. Winding it down, maybe only one more witness. And we've had two trials, and the first trial seemed to drag on and drone on forever during the prosecution's case in chief. This one has been much tighter. What are some of the differences you've noticed in trial one versus trial two from the prosecution side?
Brennan is a much more effective storyteller. Like, it is night and day. Lally's opening was absolutely awful. Like, just if I was teaching a law school course and a law student did that as a sort of project opener, I'd be saying, we should have a talk, and maybe I'll give you a do-over on this one after we've had a talk about what makes an effective opening. Because it just...
You know what's funny? You say that, that's what it reminded me of. It's like a first year, how do we do an opening? We just purely tell a story with timelines and witnesses. I agree.
And I mean, there's a great place for timelines. Timelines can be fantastic. Mm-hmm. And I watched an opening that I thought was actually really effective. I don't know how they got away with it, but they had a clock on. They brought in like a clock with little movable hands out of paper, and they would just tick it over and say, at this time, this is what's happening. And then they'd move it over like 5 minutes and say, now we're at 12:17. That's when this guy leaves his house with the gun, and then ticks it over. He drives for 11 minutes. He arrives at the house of the victim. Mm-hmm. And that was really effective. And it's a timeline, but it's, it had a visual aspect. I think a lot of judges would say you can't do the clock, but just the fact that there's a rolling time. His timeline was droning. And then he goes into every witness and how they know every other witness. And by the end of it, I was lost as to what their theory was. It's like, well, I guess they're saying that this is a murder case, but I don't really understand how or why. Brennan, on the other hand, he gets up and he tells a story. And he hasn't gotten bogged down in some of the details that Lally loved to reiterate. It was snowing. How much was it snowing? So much. Were there, what table did you sit at? Was it a high top or a low top? Nobody cares. Brennan knows nobody cares. Lally really wanted to tell the full story of the night. Brennan has very much chopped it into what he sees as the critical moments. So basically the entire, bar outing has largely been eliminated, other than just she had a lot of drinks. That's what we got out of that. And that's really what he needed, not hours and hours. Lally was basically trying to run the defense case before the defense could, and saying, look at the defense's argument, the one they're going to make, it's awful. Brennan is doing the smarter thing of letting the defense make their own argument when they get there, rather than trying to do it. So he's told a much cleaner, more consistent story. The problem is that he's trying to play chess with checkers pieces. All of the ingredients he's got for this soup he's making are bad. He's got, Trooper Buchanan, who is his solution to not calling Proctor. And Buchanan, I wish every police officer that I had to cross-examine was like Buchanan, because he was stubborn. He was refusing to understand simple concepts like theory, the word he'd used 30 seconds prior. He doesn't come off to me, and I mean, ultimately the jury gets to decide. They can decide I'm wrong. They can say, we really love this guy. But to me, he just, he came off like he was lying, and he came off like he was deeply partisan and trying to cover things up. Hiding Proctor is going to be a really big issue. I was saying it yesterday, and I think there might be jurors on that jury pool who think Proctor is dead based on the way he's been presented.
That's interesting.
Because Buchanan literally said, we work with more than one person because it's a dangerous job. Sometimes people die. And then and I could absolutely see the jury sitting here right now going, oh, this Trooper Proctor maybe said some bad things, and then he died, maybe in the line of duty heroically. And the mean defense lawyers are pointing the finger at this guy who can't defend himself. And they might be quite surprised to see the actual person walk in the door called by defense. And the first question I'd be asking is the defense calling him is, so, Mr. Proctor, how are you currently employed?
Exactly. I mean, it's like Brennan's making the soup and looks like a good chef, and he's got the good chef's hat on, but he's using rotten eggs and everybody can smell it. So no matter what it looks like, no matter, what people think he's making, it's like there's still a very obvious scent and smell to this case, like very obvious.
Yeah. And it's interesting because he's abandoned, Trooper Paul, but then they brought in Burgess, and Burgess caught fire in a spectacular way. I think Burgess's career is probably done after his CV's been pulled now from the website. That was up yesterday, or that was up a couple of days ago, and now it's gone. I saw lots of people saying, is he going to get fired right away? I don't think they're going to fire him while the trial is going on, because aperture would look really bad to the Commonwealth, and by extension, everyone else, if they gave the defense the ammunition of firing their expert midway through. But his story is unbelievable to me. And part of the unbelievability is because I've hired experts. And this notion of the expert just doing a bunch of their own work, just for nothing. Like, I just felt like doing some more work on this file midway through trial is just, no.
It's not normal. It's definitely not normal. And it's definitely not normal if he's not watching the trial and getting new information that would lead him and make him want to do more of an investigation. And I mean, that is also, there wasn't a ton of that the first trial, right? And there wasn't a lot of, Hank Brennan is more willing to, I don't know if ambush is the right word, do what he needs to do and deal with whatever the even though there hasn't been a lot of tongue lashings, if that was going to happen, he's willing to take that chance. Like Lally, when you talk about his timeline, not only was it boring, it was also wrong. And when you say what every single witness is going to say, it makes those witnesses even more boring. Brennan added some intrigue to his story, so you'd want to hear what those witnesses were going to say. Very different presentation, very quicker, very, very tighter, much quicker per witness and piece of evidence. And like you said, we didn't have to see every single drink handed to Karen Reed. It was more like, she said she had this many drinks. This was her blood alcohol level. Call one witness to talk about how she was drinking a lot. There's just a much simpler way. It's like he went in a straight line as opposed to all over the place to get where he wanted to go. So I would agree with your estimation that it is a much better story. It's much easier of a listen and less boring. He focused on the more important facts, but he's ignoring very serious issues that Lally, love him or hate him, you think he did a good job or bad job, he jumped on those grenades first. He tried to take away the sting. He had a plan to at least eat around the bruises of his case, and as opposed to pretend like they don't exist.
I mean, the whole thing of Proctor just not being called is bizarre. And the other one I'm wondering about is Trooper Paul, because if I'm on the defense, I might be considering calling Trooper Paul. Just, they're going to bring in this accident reconstruction expert who I suspect is going to tell a wildly different story than Trooper Paul. And I bet Trooper Paul is a bit salty. I bet he's a little pissed off about having been sort of sidelined on this, and bring him in and just be like, so you testified in a previous hearing. Can you run us through your theory at the previous hearing? Okay, so that was your theory. Why aren't you here now? Why this? You were called by the prosecution to present this theory, and just let the jury know, especially when you've got Burgess and his evolving theory, that basically they're willing to say anything so long as they think it'll convince you, and they're willing to just keep on trying stories until they think one lands. They don't even know what's happening. How can you be at beyond a reasonable doubt when even the prosecution's still figuring this out?
Yeah. I think Paul, I don't know if I would call him.
It's a risk.
I don't think he'd be friendly to the defense at all, but I do think you should be able to get into his theory while Welcher's on the stand and say, the Commonwealth had a theory. They had an accident reconstructionist. This is what he said happened. Is he right or wrong? Why is he wrong? Because this was his theory. He worked for MSP. He is their accident reconstructionist. He's been called at prior hearings or proceedings. Like, I think they should be able to get into all that. How much Judge Cannoni will let them, I don't know. If there is only one witness left, obviously it is Dr. Welcher, so we don't necessarily know exactly how that's going to go. But that's extremely important to obviously prove that there was, in fact, a collision in this case, which both of us, I think, would agree. They have zero proof of so far that there was actually a collision in this case. But what do you think the Commonwealth has actually proven so far? Like, let's start out with, because I know there's going to be issues with everything, right? There's issues with everything. That's why there's cross-examination on everything. But let's start out with, if Ian Runkle is a juror, what would you say you feel confident happened beyond a reasonable doubt? Have they proven anything to you?
Death by brain injury followed by cold. I'm there on that.
Good.
The cause of the brain injury, I'm not, I don't know. I've got multiple possibilities.
Okay.
Some of the timeline elements that are really not in dispute, the things of what happened beforehand, what happened after. But on all the critical details, I've got questions. How does the tail light end up there? I don't know, and I wonder about all of this. We've got this issue of microscopic pieces of tail light, and that might be convincing if I wasn't so badly shaken with everything else that's happened. They've got experts who are testifying to things that I think are quite helpful to the defense. They had the neurosurgeon, who I thought was a great witness. I was actually going, this guy is actually really, this guy could sink the case, right up until he gets up and looks he seems to be looking Brennan dead in the eye when he says, this is really common. We see these where people get drunk and they slip and they fall and they get exactly this head injury. And I was
like, whoa, that's a gift. That's a gift. But let's focus. I know there's going to be a lot. We're going to talk about reasonable doubts, and we're going to talk about the reasonable doubts the defense has kind of highlighted. But I want to ask you some questions about facts, and you tell me whether or not you think they've proven these facts. So that Karen Reed's Lexus was driven by Karen Reed and John O'Keefe was in the passenger seat. Do you feel like they've proven that to you?
Yes, at some point in the evening. Yeah.
Right. Okay. What about around 12:30? That Lexus SUV was outside 34 Fairview.
Somewhere around there. And of course, the actual seconds. Yeah.
Correct.
She's in the area. Yeah.
Okay. That she had too much to drink.
Yeah. I'll give him that one.
Okay.
I don't think there's a single person in Canton that night who was sober.
Right. And that's fine. But I'm trying to figure out, I'm really trying to just be laser focused on individual facts. Have they proven them to you? So, okay, so her car is there at about 12:30. At some point after 12:30, her Lexus SUV had a triggering event of going in reverse. Have they proven that to you?
Yeah, that'll accept that it went into reverse. It seems reasonable, and I don't think it was really contested. Like, the defense seems to agree with it. The issue is timing. So
Right.
yes, I
Timing
think
and how
that one's
fast, right? I don't think Burgess said, did Burgess say how fast it was going? Did he say 24 miles an hour or whatever?
I don't know if he said 24 miles
I
per
may be
hour. If he
mixing that
just
from the last trial. I assume Welcher's going to get there, but okay. So it is going in reverse at some point, and that John O'Keefe at some point got out of Karen Reed's car.
yeah.
Okay. And at some point was standing in front of 34 Fairview. We don't know if it was in the lawn, in the street, in the house, but at some point he's out of her car in front of 34 Fairview.
Yeah, somewhere in that vicinity. So yeah.
And okay, so here's another question. Karen Reed. So let me ask you these questions. What time do you think Karen Reed left 34 Fairview?
I don't know. And
good answer. That's a perfect answer. You can stop right there. And the answer, and the reason I'm saying that is, as we know, if you don't know, you can't convict her. So what time did she get to John O'Keefe's house?
I don't, like, this is the thing, is the timeline is so messy and muddy. I just go, when you start getting down to the seconds matter here, I don't know. She
Right.
got there at some point that evening.
Right. And that's kind of what I'm trying to give. I would say me and you are on the same page right now, because I would agree with you that they have proven all of those facts. Her car was outside 34 Fairview. The head injury, I would say I am more confident probably in the head injury than you are, to where maybe I'm just saying he hit it on something. It could have been the ground, could have been a bench, could have been whatever, because the neurosurgeon did leave that open as well, that not necessarily a ledge or edge, but could have been, or could have just been the flat ground. But that's what ended his life. Not hypothermia.
I think it was a head injury, or head injury followed by cold. Like, that's my.
And I agree with you.
Yeah.
Right. So if we're talking about that, that basically the timeline, her car is there around 12:30. John O'Keefe gets out at some point. She's driving after drinking too much. We feel confident about, the head injury, and we know she backs up at some point and leaves at some point. We just don't know when. We know she ends up at John O'Keefe's house. We just don't know when. Okay, here's another question. Do you think Karen Reed wanted to end John O'Keefe's life?
No, I found that evidence to be entirely. I have seen better evidence on that it's so weak. It's so pathetic. The all of that. They're like, oh, they sent some nasty text to each other. I deal with, domestic violence cases all the time, and I can tell you this set of texts wouldn't even register in those, cases. It's just it's such a mild dispute, and at the end of the day, I just don't see it. Like, right. They have not convinced me on that.
Yeah, I think they have proven she did not mean to. I think they have presented facts in their case in chief, including her interview statements, that have proven to me she did not, if she did this, she did not know she did it. Like, absolutely proven to me beyond a reasonable doubt. So we're on the same page there. One other thing, I'm sure you agree with me, his body was in fact found on the lawn of 34 Fairview the next morning, between 5 and 6 a.m. We're all in agreement there, right? So there are some things that they have proven, and some of those things can track you towards the crime. The problem is they've got no motive, at least for the highest charge. They've got no causation of the injury with, did a vehicle actually hit him? And we're waiting for that witness, so that's still kind of an open item. And from their perspective, they're getting there in spite of a horrible investigation, right? I mean, that's something they've also proven to us, that this was a terribly done bad news bears type of investigation, which leads me kind of to the defense. And so we started out talking about the prosecution, difference between trial 1 and trial 2. And I think we both agree, from what lawyers, right? We have to realize we're lawyers. It feels like trial 2 is much better. But let's not forget, Lally had 8 people voting guilty on a lesser included of count 2. So if this ends up being a not guilty across the board, we can say whatever we want. However, he mumbled and bumbled his way down to get multiple guilty votes. He did. I feel confident about what we heard from reports from the jury, that there were, I don't know if there was 8, but multiple guilty votes on a lesser included of count 2.
I also feel like the defense is running a better trial
That's it.
this
So that's
time
my
as well.
question. So how compare defense trial 1 and trial 2?
Defense's opening, I liked their opening, but I liked it from the perspective of a defense lawyer going, man, that's audacious. And when I started covering the trial, I hadn't followed any of the trial up until that point. I started doing the recaps because I watched that first opening and went, there is no way he's going to deliver on this. And I thought it'll be fun to cover the moment that this falls on its face. And I was kind of stunned to get to the end of the trial and go, why did that not fall on its face? But it's still too bold and it's still too strong of a statement. Because you're trying to convince the jury to basically accept the things juries never want to accept, which is that police corruption exists and that there are, not just bad cops, but like bad departments. And that, like, now they've got much more of a sort of villain figure in Proctor, and they've been much better at tying things back to Proctor. Alessi has also been incredibly effective.
Yeah, good addition, really good addition.
Oh, he's amazing at dealing with these experts, and sometimes I'm taking notes of things I want to talk to with the viewers, and sometimes I'm taking notes of things where it's like, I need to steal that thing he keeps doing.
Absolutely.
Yeah. So the way he's taken some of these experts and gotten some really good admissions out of them, and really taken some of them he's just like stripped down to the bones. And I just think that he's been a really big help. They've really run a tighter game again. So this is kind of, you're watching both sides doing better, and they both sort of got some anticipatory advantage because they had that first whole trial. They saw the strengths, they saw the weaknesses, they know which witnesses are vulnerable and how, and so they've avoided some pitfalls. But I mean, I tell people, and people hate hearing it, I tell people, like, there is a very real possibility of conviction here. And that is notwithstanding that I look at this, and if I was on the jury, I can tell you I'd be sort of I've got my position, and I don't think you can move me from it. It's just, I don't see how, like, any juror could make a persuasive argument to me that that they are at proof beyond a reasonable doubt. I get people on Twitter going, well, isn't it possible that she killed him? And I went, yes, I think it's possible.
That was going to be a question I had for you in the future. Do you think it's in the realm of any possibility that she actually did hit him? And I would say I think it's possible, unlikely based on what we've heard, but possible.
I don't think it's what happened. I don't like, it's not, if you sat me down and you gave me like 1,000 in chips and said, put them on the board of what you think happened, it would not be Karen Reed hit him with the car. It would be, and if I could, I'd be putting it on, I don't know, and we'll never know. But maybe someday somebody drinks too much at a party and, and more story leaks out. The number of cases where that's happened, a decade into the future is not small. But, I mean, the other, like, at the end of the day, it's possible that the neurosurgeon's version of things is what happened.
I agree. Or that even that argument backed up and he tried to avoid her car and fell, and some other animal came and bit his arm. I think that's as plausible as anything too. And that's kind of the problem with the Commonwealth's case. He could have been beat up inside. He could have tripped and fell inside and they threw him in the yard. He could have slipped and fallen on the grass just himself. It could have been because of a maneuver Karen Reed did with her car. I mean, it is really, really, really hard for me to try and find a possible way she actually collided, like actually physically came into contact with him with her car based on his injuries or lack thereof. But I mean, I guess if somebody's like, is it at all possible that some crazy way he got those scratches? I mean, I don't see how it's possible, but I mean, I guess I'll leave like people say anything is possible. That's basically where I'm at with that.
If I had to put money down, I'm sort of at the O.J. Simpson case. And my sort of belief on O.J. Simpson was that O.J. Simpson was guilty, but that they tried to improve the case. And here, what I think is going, if I had to put money, it would be Karen and John are fighting. She speeds off. Maybe she flips in the bird. She takes off. And he falls. He doesn't make it to the house. He falls in the yard. And she's taken off angry. And she doesn't make it far before she's sending him messages, basically, insulting him, trying to get him, and maybe everyone in the house is telling the truth that he never made it in the house. Maybe he collapsed in the yard and just nobody knew he was there. Karen thinks he's in the house, who's partying. He thinks maybe, she thinks maybe he's cheating on her. But then afterwards, I am convinced that the investigation itself was messed with. And that there were steps taken. And my take is maybe they had this case of this mystery. They decided she did it. And then they decided to improve their case because they looked at it and they said,
happens. Like, we know that happens. We know that happens.
And maybe they looked at it and they said, we think she did it, but we just don't have enough things. So maybe if we move a little evidence around, create a better story, then we end up. And like that I can very much believe, but that's still
So because I have a bunch of questions on what the defense has shown you so far, but what you're saying is, like, that theory to me, I think, is most plausible as well. Either they think she did it, they truly think that she is guilty, they wanted to prove it. And we also know how many defendants take plea deals in situations like this, because if you get offered 5 years or 10 years, that's a lot shorter than life. And if you go lose, you get life. And they're telling you they've got the hair right here and they've got the pieces of taillight in his shirt. You better take a plea deal. Most of the time, defendants take plea deals in those situations. They just do. And so cops, maybe they've done this in the past and they've gotten used to it and they don't think it's any big deal. That's the point. And of course, we've got the Birchmore situation and whatever, to where, like, maybe there's more plausibility to that than we think. But I would agree with you. I think the defense is doing a much better job this time on the overall way they look at the case. Reasonable doubt, you can't prove it. Horrible investigation. Proctor is the villain versus Albert, McCabe, Higgins inside the house, clearly beat him up, because I don't think it's clear. I just don't think it's clear. Same thing as you. The conspiracy seems impossible to prove. Doesn't mean I'm not going to ask you if you think they've shown it so far. But I think that has been a much better job. I also think they've nitpicked less. There's still some nitpicks, but last time I remember multiple clunky Jackson back and forths on like one word difference that wasn't that important. I think he has done an exceptional job controlling his hammer, because he has an absolute hammer and smashes witnesses. And I think it's been a much more tailored use of the hammer than the first trial. I love his demeanor and the way that he does it personally. That's kind of the style and vibe I like. I know a lot of people like different styles, but I think he's done an exceptional job, especially with this last witness. He was very nice to her, but that demonstrative aid buried her about what glass came from where.
I mean, that witness seemed terrified of him. Like, she was, and you see moments where he's showing her a picture and she's like, I didn't take this picture, so I don't know. And he's like, I'm not here to go after you. I'm just, because what he needed from that witness is, you did this analysis. This is your, diagram. I just need you to walk through it with me, and I just need to explain it with you, and so forth. He's like, I'm not here looking for, your blood on this one. She was just like deer in the headlights.
This was one of the first witnesses that I can remember all trial, him saying, hello, Miss Hanley. It's nice to see you again. It's been about a year, right? We met last. I don't think he's done that with very many witnesses. And she was like, yeah. I liked that. That was funny.
Whereas Alessi, every time there's an expert, he'll, he introduces himself and he says, and I believe him when he says, like, it's nice to meet you. And it's nice to, and then, some of them he tears apart and some of them not so much. And some of them it's, I mean, and I get a feeling that some of them he means it a little more. Like when he was dealing with the neurosurgeon, he was like, I got the sense he was like genuinely would like to like grab a beer with that guy later, kind of thing. But it's.
I agree. So, Okay, so we both agree. The defense is also, I think both, it's a better presentation, trial number 2 from both sides, which is not uncommon. Lawyers with preparation and time and information usually improve. That's what we do. People can't understand how lawyers don't know the answer to every single question. Well, guess what? That's because in life, when we get a big question or have a case, we always research it. I don't care how many times I've answered the same question on a case with a similar fact pattern. I'm going to research it, make sure it's up to date, make sure I have the right answer, make sure I can explain it. That's what lawyers do. Research, prepare, write, explain. And when they have a second bite at the apple, usually it is better. So on this round 2, and realizing we have not gotten to the defense's case in chief yet, I do want to talk about that a little bit with you. But just with what they've done in cross-examination and what they've presented during the Commonwealth's case in chief, do you think they have proven that this was a faulty, horrible, inept, whatever you want to call it, investigation?
Oh, absolutely. And I mean, if I was teaching police officers, I might bring this in just to say things like, listen, I actually got an offer at one point, like, would you as a defense lawyer be willing to teach police? And I was, but it sort of fell apart. And I think that this would be a great case to bring in, just to be like, let's watch this and let's watch. Tell me how much fun you think this officer is having when he cut all these corners, when he made all of those comments, via in their group chat. It's like, do you really want to be in that group chat? Think real hard, about, and, I would like Buchanan with his, I acknowledge the message with the, I don't think anybody buys that, but what would have been so much better for Buchanan is if his response to that was something like, this is inappropriate. We're going to talk about this on Monday. Yuri Buchanan has left the group. That kind of thing. And I had somebody at one point try to hold me to account for participation on a Discord. And, there was a Discord where there's a whole bunch of things and they're like, you were on this Discord. I'm like, yeah, did you see my messages on the Discord? And they're like, well, you sent messages in the middle of this discussion. So they pulled them up and the messages were, this is not something I agree with. I'm out, and then has left the. So that's where you want to be, is the guy. There's so much police should learn from this, and so many corners that were cut that were just. It's hard to imagine why they'd cut them. It was so unfathomable. Like, we need to collect this blood evidence. We're going to use a red Solo cup because that's what we have here. Send somebody to get the real thing. Just do it.
And guess what? When you say it took us 10 minutes to gather, it's like they had to drive 1.5 miles in a snowstorm. And everybody would understand that because it's impossible to do anything else. It's not impossible to use something other than a red Solo cup. It is impossible to make the snowstorm go away or not have to drive to the station. That's an impossibility. There's nothing else we could have done. No police expert would point and say, you shouldn't have driven back to the station. Of course, that would have been the appropriate step. The crime scene, the way they did not secure it, the way they did everything with the crime scene was basically horrible and a joke, not to mention how they found pieces for days and weeks after just driving by the house that somehow the Alberts inside the house never saw.
It's a murder case. I'm shocked that they didn't literally comb through that. They go through. I was expecting they'd go through, they'd do a search, they'd dig through, and then they'd bring out heaters, melt the snow in the area, go through it again, and then go through with rakes to see if you can find any little fragments. And just, it's a police officer's murder case. I have seen them do things like go in there and cut the sod up, roll the sod up so that they could take it, and keep it. The budget for a police officer murder investigation is essentially unlimited.
Exactly.
After the fact, we find out that they bought an entire Lexus for this. You couldn't post a couple of guys to just watch the scene and secure the perimeter and say, these guys who are uninvolved, they, guy 1 is watching guy 2 and vice versa, and they know that no one made it, entered here. That would have.
CERT had to call it after 45 minutes or whatever. I was like, why? I never understood why. You couldn't just search the whole house, front yard, backyard, driveway, street. Why wouldn't you guys just stay there and search the whole place? You had found, they're like, we found enough. And we were like, all right, that's good. We're going to call us if you need us. And Proctor's like, I got it. Don't worry.
They take 6 blood samples in the solo cups and they test one cup twice. And I'm going, but you know that they're like, why wouldn't you? Are you short on tests? Like, are the test strips now too expensive? Just test the things. They end up with these, oh, we found DNA. It was from John O'Keefe and an unidentified male. And I go, what do you mean an unidentified male? You should be doing your absolute best to identify who this male is,
or at least exclude some males, right? Exclude some males involved.
Yep. Like, go up to everybody who's in this, case and just be like, okay, will you provide a sample? And I bet most of the people would provide a sample voluntarily. There was a case here where they were looking for like a serial offender, and they went around in the neighborhood and they asked everybody to voluntarily provide a sample. And they had something like 96% compliance for just like going to every guy who lived in the area, in the neighborhood.
Yeah.
And will you give us a DNA sample?
And me and you were the two that said no.
That's pretty much it. And like, I'd be sitting there going no, and I'd be to the top of the list just because
Exactly. But I'll always say no. Put me at the top of the list. I don't care.
But, why they didn't even ask when they're saying, oh, we couldn't have gotten a warrant to look around in the house. I went, but did you ask for a consent search? Because, how many of your clients have, when they're in a car full of drugs and guns and, and the police say, do you mind if I have a look in your trunk? You can say no, like this is, and they go, oh yeah, sure, bro. Let me just pop the trunk for you.
I got nothing to hide.
Yeah. And then you ask them later and they're like, well, I didn't think he'd actually find, like, I thought if I was really cooperative, maybe he wouldn't look or he wouldn't find it. I'm like, you had 3 AK-47s sitting on top of a kilo of cocaine in a trunk that is otherwise empty. Did you think like the angels were going to, but I mean, they could have just, and if you think Karen Read is guilty, you wanted the police to do all these things too.
100%. That's what I've been telling everybody this whole time is it sucks for everybody on every side. Everybody should be mad about this investigation. That's the point. If you're the O'Keefes, if you think Karen Read did do it, if you think she didn't do it, if you're the Reads, everybody should be pissed off at this investigation or lack thereof. And I think you're right. I think the defense has absolutely proven beyond a reasonable doubt this was an inept and horrible investigation, which is interesting because they did it through cross and during the state's case in chief, Commonwealth's case in chief, and without an expert, which they were trying to call. The judge did not allow them to call. So they had to make sure they made it readily apparent and very clear during other witnesses, because they were not allowed to call a witness to be able to summarize all of it and just explain how bad this is, which I think this is the case for that. And they should have in Florida, we're allowed to do stuff like that.
It's astounding to me that Easter was disallowed. Yeah. And then she's like, oh, I'll allow a robust cross-examination. And the instant they start asking, like, do you think this was proper police procedure? It's objection. Oh, sustained.
Yeah, I would like to ask this Judge Cannoni, when are you not going to allow me a robust cross-examination? And whatever her answer is, I'm going to be like, that's unconstitutional. I should be able to get a robust cross-examination on every single witness in every single criminal defense case. So I don't even know what that's not a remedy. That's not a remedy. Are you going to let me ask about inadmissible things? No, of course not. So that's not what a robust cross-examination means, right? But what do I know? Okay.
It's weird that she offers that as a remedy when it's really, it's really what they get anyway.
Yes, exactly. Okay, so definitely crime scene, Proctor, bad investigation. What about the timeline? What do you feel like the defense has proven as far as the timeline goes? We agree Karen Read's car is there. Do you think the defense has proven to you when her SUV left 34 Fairview?
The problem I would say that I don't think the defense has proven the timeline either. And the issue I have on the timeline is I don't know. It's possible the defense is right. It's possible the defense is wrong. The timeline makes no sense. And so all of the evidence I have from the timeline, at the end of the day, I just have to go, and it might be that there's another expert that comes in and can make it make sense to me. Because right now the defense is just at the poking hole stage.
Correct.
But
and they don't ever have to prove anything. We know that. We're lawyers. Okay. Thank you for everybody in the comments. But as a thought discussion in your head, if you're a juror, have they proven that to you? Because I've got some thoughts on where I would be as a juror. But go ahead, finish yours.
I think my feeling is no. My feeling is just I don't know the timeline on this at the end of it. And it might be that's just me not taking good enough notes and not
I think that's
parsing things out. But
I think that's where most people should be, really. But if I want to really dig in and try to figure out what the defense has proven as far as the timeline during the Commonwealth's case in chief using the Commonwealth's own evidence, I would say the Commonwealth has tried to tell us that 1231 and some change to 1232 and some change, she's backing up and hitting John O'Keefe. And then obviously after 1232, she is going forward and driving to John O'Keefe's house at One Meadows, which they say, their own witness says she connects to his Wi-Fi at 1236. They say her Lexus turns off at 1242. We have a voicemail at 1241-ish where you can hear her and it sounds like she's getting out of her car, walking inside. We have a clip of Karen Reed saying that's exactly what she's doing at 1231. So to me, it almost feels like with the Commonwealth's own evidence, she is either pulling into the driveway or into the garage at 1236, sitting in her car, dialing John O'Keefe, leaving a message for a couple minutes as she walks inside. I agree with you that no, they have not proven it, but that seems like a plausible timeline. Nobody to me has fully explained exactly how long it would take in a blizzard to get from 34 Fairview to One Meadows. I assume the defense is going to bring somebody out that says that. I think Kerry Roberts or McCabe may have talked about it. It wasn't clean. It wasn't clear. But to me, I feel more confident in that timeline than anything else. And to say if Karen Reed returned home between 1236 and 1237, to pull up the driveway, however far a Wi-Fi can reach, and she's sitting in the garage until 1242, 1 or 2, the Commonwealth better prove to me that's possible with a 1231 or 1232 time of collision.
This is the problem, is like the Commonwealth's theory of the timeline doesn't make sense to me. It's she's committing murder and then she has to fly directly back to John O'Keefe's place. And I don't see it, especially when they're saying it's the worst blizzard ever.
The cops were not willing to drive 1 mile back to the station, but we're supposed to believe she flew home while she was intoxicated. And they played a clip that she was probably driving carefully and slow. And Ryan Nagel said she was driving carefully and slow. And didn't the Lexus data say she was driving slow?
Yeah, I mean, maybe if their case would be so much better if they'd found her wrapped around a pole, 6 blocks away, right? Then, okay, cool. We know what happened there.
When she was there.
But instead, they've got this really tight timeline that just doesn't seem to fit the weather conditions, what we've seen of her driving, what we've seen of all of this. Suddenly, she's got to have been driving like a crazy person in this blizzard, and yet somehow has no issues on that route. Notwithstanding the fact that, according to the Commonwealth's theory, she's crashing into everything. Right? She's crashing into John O'Keefe's car. She's crashing into John O'Keefe. She's just playing pinball with her vehicle.
Yeah, she's ignoring backup beeps and everything, but we can hear them in the garage. You're right. It just doesn't make sense. It just doesn't make sense. But I do think the defense has definitely highlighted things they're going to bring out in the timeline that could create real reasonable doubt in the Commonwealth's timeline. I've got a couple easy ones for you. Do you think they have proven at this point that John O'Keefe was not hit by a car?
I don't think they've proven that he's not. But I'm at the point where I give it no credit. It's a difference between proving the negative versus my confidence that he was hit by a car at this point is at 0. So
And Jackson's opening probably made some jurors start there. Like, they say there's no collision. There's nothing that tells me that's not correct, right? It's the double negative, but still, like, they did a very good job making sure they highlighted that. Another one, bit by a dog. Do you think they've proven he's bit by a dog yet?
I mean, we haven't seen any evidence of bit by a dog, but you know, I look at the injuries, and when they say this is a Lexus, I just go, huh? So, I mean, I'm at, like, we haven't had any evidence of what these injuries are that I find credible, but they don't have to. I mean, if they just tell Dr. Russell to go home and I'm on the jury, I'm like, well, I don't know what those injuries are, but I don't think they're a Lexus, and I'm certainly not at proven.
So it is wild. Like, I mean, we'll see what Welcher's allowed to testify to, because the ARCA guys were not allowed to say certain things about causation of injuries, but the ME and the neurosurgeon, they didn't even ask him, could these scratches have come from the broken tail light? They didn't even ask them. So if Welcher doesn't testify to that, you can tell the jury as the defense, they didn't even tell you. So where did these scratches come from? The only evidence that is presented to you was that these came from a dog, because that's what Dr. Russell says. They presented no evidence. That should be an easy understanding for you guys as to where those scratches came from, because they haven't even tried to say where the scratches came from. And we have heard about Chloe, but I would agree they've definitely not proven he was bit by a dog at this point. They'll have the opportunity to do that in the defense's case in chief and proven, of course, they don't have to prove beyond a reasonable doubt, but just will it become a reasonable doubt for the Commonwealth's case? That's still an open item. And then again, we're talking about the Commonwealth's evidence during the Commonwealth's case chief. And by the way, we also know the fact that we're even having this discussion and questioning, has the defense proven this during the Commonwealth's case, is so unusual, because usually the defense can't prove much of anything during the state's case in chief, because it's usually a much better state case and a much weaker defense case than we have here. But again, going what we're talking about, Dr. Wolf and the drunk Minnesotans falling on their head, do you think they've proven that it was a slip and fall?
I don't think they've proven it's a slip and fall, but I think that with that, they've established that it's possibly a slip and fall. And I mean, from usually when I'm running a case, that's all I need. Like, that's all you want. Usually I'm arguing a case where it's like, you know, the prosecution has proven almost everything, and the argument is, well, isn't it possible that it's a slip and fall? And that was during the Commonwealth's direct. It wasn't even elicited on cross-examination. He just comes out and he's like, yeah, we see these all the time. And, you know, it's people get drunk, they fall on and they hit the back of their head. It looks exactly like this. And it has exactly these injuries. And I'm going,
to me, the way that came out, it is not just a mere possibility. I would say that neurosurgeon, that was the number one first example of how he explained he sees this head injury from blunt force, is a drunk person slipping and falling and hitting their head in the snow. Therefore, it is not just a possibility. It is a very reasonable possibility in this case. And if it's a reasonable possibility in this case, that is obviously a reasonable doubt. Like,
yep.
I don't think they're going to sleep on that unless he did not really dig in on cross, which I think is smart. Don't let that genius explain his answer away. You've got his answer. Use it. Brennan probably should have gone more into it. Like, are there reasons you don't think that happened in this case? I don't really know what his answer would have been, but unless he didn't even touch it, that's in evidence to me. While the defense has not proven it, and that's why I'm using this verbiage, that is a very reasonable possibility in this case as well.
I mean, if I'm Alessi and there's no way I touch that answer on cross, even to just highlight it, because if you highlight it, then Brennan gets to come back and redirect on it. You just leave that way alone. But I'm betting that during the close, they'll say, you heard from a renowned expert neurosurgeon. This is not a man who testifies for a living. This is a man who does brain surgeries for a living, who came out to this trial and he said, this looks exactly like what he sees all the time. Somebody drinks too much, they fall, they hit their head without any without any vehicle impacts, without anything like that. It's their own expert said this could be a pure accident.
You know what I might say? Just to make sure, because it was kind of quick and it just happened and the jury's listening to a lot and maybe they missed it. And I wouldn't bring it up with him again either to highlight it. But before closing, what I might do is with my medical examiner, or if I'm the defense with their medical examiner, maybe say, we heard from Dr. Wolf, world-renowned brain surgeon, that this is very common in Minnesota for people who are drunk and slip and fall in the snow and hit their head. Would you agree with that opinion? Yes, yeah. I would agree with that opinion. I would ask my expert that question. So it's highlighted again. And now what I like to do in my cases, which are injury cases, and they're trying to argue certain injuries didn't come from this truck hitting somebody or whatever it may be, I like to do a chart on even where all the experts agree. And I'm like, just if we look at where all the experts agree, we win. In this case, it's the same thing. That slip and fall, every expert we talked to agreed that's a reasonable possibility. It's over. They cannot prove that this happened by a car. This could have been a slip and fall. There's no injuries. And I'll tell you, from my perspective, somebody, again, who deals a lot with car accidents, it's not even the injuries John O'Keefe did have that make me think it's not a car accident. Like, was that a dog? Was it scratches? It's what he didn't have. No broken bones, no serious bruising, no internal injuries. Like, people, I've had clients that get hit going 5 miles an hour, get hit in a crosswalk, and they've got 2 broken shoulders and a broken collarbone because of the way they fell after they got hit by the car, or run over their foot. It broke every bone in their foot. Like, it doesn't take 25 miles an hour in reverse to get hit by a huge SUV to do real damage to a person.
I had a case where somebody was clipped by like a small sort of, city car, and they were hit by the mirror, and that's it. They weren't like, pirouetted. They weren't any of that, but the bruise that they got wasn't, it wasn't like, this shade of blue. It was like this, it's hard to tell that this is a blue, but it's like this shade of blue.
Yeah.
And, just that deep black, and I'm going, how is it that John O'Keefe supposedly takes enough force to throw him to the ground, to rip open his arm, to, all of this,
to break the taillight?
Yep. Oh, and those taillights, they don't break easy.
By a side swipe.
And then he's got no bruising whatsoever. It's just, and there's lots of lawyers sort of locally who are not following this case. And so I've sent some of these pictures to some of them just to sort of get a sanity check. And so I sent off to them like, hey, here's the picture. You know what the defense lawyers were saying to me when I showed them the picture of the arm injuries? They were saying, which police dog is that? Because we want to note that for our files for when our client gets bitten by a police dog. Then we can say this dog has a history of biting and attacking people. And saying, well, no, this is from a nationally televised case. They're saying this is a vehicle injury. And they're going, no, this is dog bites.
And the other thing is, one thing we like to do too is because like a lot of spinal injuries in cases, right? And it's herniations and soft tissue stuff. And some doctors will say you can herniate a disc sneezing, whatever. But on some of, even if it's a case where, the axle of a car is bent or the bumper is broken and falls off, we're like, do you know the force it takes to break a bumper or bend the frame of a car? Well, that force goes through the car. We have somebody explain how, somebody's body moves. That takes a lot of force. So to hit that taillight with your arm, that taillight is like as strong as the bone in your arm. It's like, this doesn't make sense to me. Just physically speaking, it doesn't make sense. And that's again, we're kind of going on a tangent of why this is such an issue. But okay, so they haven't proven it's a dog bite, but here's the last thing. And we'll do it in 2 parts. Do you think that they have proven that John O'Keefe was beat up inside 34 Fairview by Higgins or Albert, and there is a conspiracy with everybody in town to cover it up and throw him on the lawn and make sure they convict Karen Reed instead of the people in the house?
No, not at all.
Not even close.
No, I mean, I don't think they've even been chasing that. They've been saying that there's a possibility of a fight, and they've floated the possibility of a fight. But, if you asked me, like, if we invert this case, if this case was about trying to convict Higgins or, any of the Alberts or anything, I'd be saying this won't survive the motion to dismiss. Like, that's it. It'll be, it would
Part of
be the
that is because of
Commonwealth
how
closes
horrible the
its case.
investigation
And
was, right?
yeah, we just don't know because there wasn't an investigation. Maybe if they got the unknown male DNA, maybe that would have matched to somebody and we'd be looking at a very different case. For all we know, if the police officers had gone down those stairs into that basement, they might have seen like blood everywhere. They might have seen like a half-finished cleaning project, where there's somebody who's sitting there with the mop going, making the oh shit face as the police come down. We don't know, but
They may have
without
seen
that
nothing.
evidence,
They may have seen nothing and been able to take pictures that nothing is disturbed. Nobody's down there. There's cobwebs. They never go down. We don't know because they didn't investigate.
That's the thing is if you want to convict, like if you're saying Karen Reed is guilty, and wouldn't that set of pictures be amazing? Like, or just the body camera. We walked through the house. We looked around. You can see it looks pristine. Or even better than pristine is you can see that there were people here partying. There's some leftover, like people left cups. Here's a place where somebody spilled something that hasn't been cleaned up yet.
Yep.
And that's even better than it looking pristine because that hasn't been cleaned up. That's a scene that like a party happened. People left stuff behind. You could eliminate that somebody like because that head injury would bleed a lot, right? Head injuries just bleed like there's no tomorrow. If there's no big pools of blood or sprays of blood or anything like that, you can say, didn't happen. Something else went down. And I can just see all of the places where ordinary police work could have closed this case up to either Karen Reed goes to jail or somebody else does.
Mm-hmm. Yeah.
So
no, I agree with you, but I also agree they will never prove that. They will never prove that to a jury. I don't think they'll ever prove it to me necessarily, but they don't need to. They don't need to. I think it was a great audible from trial 1 to trial 2 to not focus on that as much. They definitely talked about it with Higgins, potential motive. Did he see the text? Did he get jealous because Karen Reed ghosted him? Did he goad or point to John O'Keefe? Let's go back to the house. Plant some seeds. But really, to me, the most effective part about that is, and you didn't investigate him, and you didn't test his DNA and blood, all this stuff. You didn't even look into it seriously because that's the Bowden defense. They didn't follow leads that they very obviously should have. So no, they're never going to prove it was him. I don't think. It is a good argument for the Bowden defense and again for reasonable doubt. Okay, last question then is, and we've already kind of talked about it. Do you think they have proven what you mentioned earlier, that the cops have poured a little extra on, tried to make sure of some things? And again, this can come back to that the only piece of glass they found on that bumper. It's hard for me to reconcile this as being anything else, but was only from Proctor. Proctor's glass didn't match Buchanan's glass. Proctor's glass didn't match the cup. Buchanan's glass did match the cup, was not on the bumper. The cup's glass did match Buchanan's, but was not on the bumper. Like, how do you reconcile that?
I cannot. I've been playing with that in my head since seeing that testimony and trying to come up with like an innocent explanation for it. And like the only innocent explanation I could think of is for some reason Karen Reed has a bunch of other random glass on her bumper, and that gets left behind, when, according to the Commonwealth theory, like she hits John O'Keefe and this other glass. And the thing is
just part of it.
You're smiling there because it makes no sense.
The rest stays on for the next 6 hours as the car is driving around everywhere.
Yeah, I mean, so I can see a couple of possibilities here. Possibility 1 is, Proctor breaks another glass, throws some of the glass behind, and or possibility 2, and I think this is the more, sort of realistic one. Proctor is at the scene. He picks up some road glass that he thinks has got to be from the cup, but it's just road glass because if you walk along the road, you're going to see glass. and brings it back to the station, leaves it there on the thing, and is like, there we go. Now we can, now this will all match up. And unfortunately for Proctor, it's not the right glass. It's just some random road glass. That to me makes tremendous sense. And it's really the only thing that sort of squares the circle. Now, I can't say that it's, 100% true. It's me playing with theories and so forth, but it's the only one.
The most plausible explanation. I mean,
yeah,
that just seems like the most plausible explanation, because it's like you said, how many glass things are out there? And I've had people say, oh, it was the little light bulb inside Lex. People are like, oh no, that's LED. Oh, well, it was, this piece of glass, or maybe he had 2 cocktail glasses, or, it's just like all this stuff. And I'm just like, you're really stretching for that. And why didn't Buchanan find any of that street glass, right? That's a hole in your theory. Why didn't anybody else that went over there for the 2 weeks prior find that street glass? And then it's like, why is Proctor picking up a random piece of glass on the street 2 weeks after this, alleged accident or incident? Like, he didn't think that this could be from a million other things 2 weeks ago? Like, that doesn't make any sense to me either.
The whole thing of like finding evidence for weeks afterwards,
problem.
It makes no sense to me. Like, they should have. This is, again, an investigation into the death of a police officer. They should have combed the hell out of it. And the notion that they're just like leaving this behind, like, how do you know some random kid didn't throw stuff around? Like, how do you know? Like, it just makes no sense to me.
Yeah. And it really is, like, what's amazing about this case is, and you mentioned it with the slip and fall. Any one of these things, if I had a trial that had evidence that was collected for weeks and weeks and weeks and not put in appropriately, that would be enough for me to make my entire defense around just that. If we had the slip and fall, you could make an entire defense just around that. If you had Proctor, you could make an entire defense just around that. If you had this timeline, you could make an entire defense just around that. If you had these injuries and the broken glass, you could, and they have all of it, which makes it, there's a lot, but it also can make it difficult to really streamline and make the jury not just kind of say, Occam's razor, Carr was there, John O'Keefe was there, Karen Reed was there, everybody's drunk, she probably hit him. That's what you got to avoid the jury from doing.
Yeah, I mean, and that seems like what the jury did the first time. Yeah. The juror Bowtie, I forget his actual name, but he was saying, oh, well, we just, we got to she was there and he was there. And so and he literally said, well, maybe there were other people, but none of them were on trial.
Right.
Which, as a defense lawyer, just had me screaming, because that's basically got to be guilty because you're the accused. I just look at all of this and it's astounding to me, but I think Brennan has really taken that to heart. His strategy is a lot more, John O'Keefe died, Karen Reed was nearby, therefore please convict. And we'll have to see if they can sort of, it's kind of the draw the rest of the owl meme. And that's really what they have to do with their last witness is,
yeah,
I'm worried that like juries are unpredictable. You get juries that like take everything and exercise their job with like the utmost. And then you get juries who walk out and they do a TV interview and it's like, so why'd you convict? And the first juror is like, well, the accused looked at me too much and I found that off-putting, so I thought he must be guilty. And then, okay, the next juror says the accused wouldn't look at us, so I convicted. And this is on the same jury. And it's like, well, what's he supposed to do with his eyeballs exactly? So we've got that sort of concern. And, you could get a jury who just sort of goes, well, he does a very cinematic performance. Like when he's, he calls a witness and then he cuts to a clip like it's a, like it's a documentary.
That's the last thing I'm going to ask you about is the clips. So I'm glad you brought that up. But no, I agree with you that you just don't know what's going to happen with the jury. But I do think in something like Shannon Burgess, I was talking to my dad about this, like he's so polarizing that those are the kind of witnesses that create hung juries, where it's like one juror that's like, it's simple enough. The data makes sense. guilty. Somebody else that says, I can't believe a thing that guy says, not guilty. And it's really hard to reconcile. And I think there's a lot of things in this case that it just feels right for. And I'm not one that ever predicts a hung jury, because you may think they should happen more, but statistics show they don't happen as often as you think. And you have people and jurors that do come to a consensus decision. But from my perspective, I can understand why this case results in a hung jury.
I mean, this one, I think more than most other cases, has the real potential for jurors to lock in, because if you sit there and you think Karen Read killed, you're not going to be likely to flip.
Who took in his niece and nephew, whose family's there crying. Like, you're not going to let her walk. You're not going to let somebody convince you to let her walk if you think she did it.
And I think people underestimate the average person underestimates the social pressures of being on a jury. When we talk about there's very few hung juries, it's because if you get one or two people and they're looking at a room of 10 other people who are like, A, this is the correct answer, and B, we want to go home, they tend to give up their position. But this one is one that people will fight for. And I mean, the sad thing is that we could end up seeing a third trial on this. And I'm just, astounded that we could end up being, we could end up watching this again. And, because I don't think the Commonwealth's going to give up. Normally, if you have two hung juries, you're just like, we're done. Yeah. Like, we're not getting there.
I've had two hung juries, one in a criminal case, one in a civil case. Civil case, we settled after the hung jury. Criminal case, we resolved it. Like, they dropped the charge down to a traffic. It was DUI hung jury. They just dropped it down to a reckless and pled to it, and it was over. So it's like that. Those are my two hung juries, and it resolved pretty quickly afterwards, because you kind of know. I told them, like, you can't prove it beyond a reasonable doubt. You really want to do all this again? You didn't prove beyond a reasonable doubt. She'll take a reckless. Let's just move on. And with the civil case, we actually got to interview the jury afterwards. Everybody was, it was a liability only portion, and then we were going to try the damages portion. And 5 of the 6 jurors were 100% on the defendant, and one was 90% on the defendant, 10% on our client. We were like, you guys just couldn't have given 10%, because that was great. We were happy with those numbers. It was a premises case. And so with that information, we were able to settle it. And it's like, hung juries can usually push you to resolve the case, not when it's this type of a situation.
I mean, with the number of problems in this case, if it was any other case, if I was defense here and this was not like nationally televised and so forth with the number of problems, I would have expected the prosecution to come back and say something like, will your client take on impaired driving, which is what we'd call it here, the DUI, no injury, like allegation, no anything, but just your client was driving drunk and 3 months. Would your client be willing to do that? And I might be able to get them down to, how about no jail? And you get your win of the, but this case, they're not going to do that. And I mean, even if they came, they're not going to come back and say, how about a DUI for 2 years or something like that? They're going to just keep trying because they want to get her in for 20 plus years.
Mm-hmm. Yeah.
And
no, it is definitely a statement type moment for everybody, and they've got to be right. And there's so much publicity that there's just no way that I don't see how this resolves. You'd have to eat too much crow on either side. And it's a wild thing, and we'll kind of see how it continues and how it goes. But the last thing I want to ask you about, especially because of the difference between the two trials, one of the most obvious and biggest differences to me is the clips of Karen Read from multiple interviews. Some of them were available in the first trial, and Natalie chose not to use them. Some of them came after the first trial, probably because Karen Read was doing these interviews thinking she was going to win, and that's how these interviews were going to come off. That's just my guess. What have you thought about the clips? Do you think they're effective for the Commonwealth? Do you think they've been good for the defense? What do you think about the way that Brennan has decided to play them? And when you're comparing trial 1 and trial 2, how does that come into your analysis?
Some of the clips I thought were really damaging for Karen Read. The problem is that the effectiveness of the clips seems to be going down as time goes on.
Agreed.
Because he's largely using them as, at this point, he's largely using them as a cinematic device. He's using them to like introduce a concept of where he's going with the witness. And I'm finding it less and less effective because a lot of these clips are less admissions and more just like a statement of things that are not even being thought about. And so I end up sitting there going, okay, but I do think it's going to be effective just in the sense of keeping the jury like interested. And I think it's kind of bizarre that this is being allowed in the way it's being allowed, because it seems to me if they're going to run this, they should have to run it as a block, not these little snippets that they're running in between. The way they're doing it seems designed to be prejudicial as opposed to actually having any probative value whatsoever. Like, I'm trying to think of the probative value of some of these clips where she just says something like, yes, the car has, like
Sensors or
backup
whatever.
lights or
Yeah,
whatever. That's like,
I agree with you in the fact that you can't call a witness 50 times throughout the trial to come say one thing and then send the witness out and then call them again on direct examination, ask them one more question. So it's kind of akin to that. I will say, though, it is hard for me to really argue with the prosecution's use of these because as a criminal defense attorney, if you let your client go talk, they can and will be used against them. And it's multiple interviews. It's not just one block, right? She gave multiple different interviews. So some kind of combination. It does seem extreme the way that they are using them. And I think some of it's been the Commonwealth's best evidence. I mean, I really do. I think without the clips, they are crashing and burning. I think with the clips, they are on the struggle bus. The Commonwealth is very much so on the struggle bus. But I think the clips have helped to tie some stuff together and have just kind of tied the bow on she was intoxicated. Like the clips, sign, seal, deliver that, right?
absolutely.
Yeah, certain timelines, how she feels about certain people, right? Gary Roberts, Jen McCabe, Peggy O'Keefe, like trying to make Karen Reed look bad, which is inappropriate, but that's what they're using these clips for. And so I don't know if the jury is going to look at her as a sympathetic figure or somebody they want to help or they want to like, which is a real thing for human beings as jurors. And I think they've been, again, we were kind of talking before about Hank Brennan. You might not like his style or the way he's doing some things, but he's been effective in some of the ways he's doing that and much more effective than Lally in the use of the clips.
Yeah, and the objection I would make, and I'd expect to lose it in front of this judge, but the objection I'd make would be all of the clips from one source should be being run together, not as this like drip, 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 just in the style of presentation. But you're right. Once she makes the statements, as a defense lawyer, I fight to keep my clients from making statements because everything that they think is helpful, there's always some portion of it that is not helpful. And they, it's hard to, you get clients and they're like, I think I did really well. It's like, okay, this line here is detrimental. And they're like, well, and I'm like, no, this is the line they're going to focus on. You can't win these games, but I don't want to be too harsh on them because I recognize they're in a very unique situation.
I get why they did it, and it's risk reward. I totally get it. I'm not saying like it's easy for me to sit here and say this. The way they have handled this has been masterful. The defense attorneys from beginning to end, the way they've had the world looking at this case, giving her more of a fair shake than most criminal defendants get. More people think she's innocent than almost any criminal defense case I've ever followed or been a part of in my life, right? And they have done a lot of that with what they've done public facing, including her statements. So I get it. But what I tell my clients all the time is, and a lot of times we're talking about their testimony in trial. It's these 6 or 12 people don't know you. I may know you. Your friends know you. They trust you. You have this good job, but these people don't know you. The first time they're meeting you, you're being accused of a crime. So they're not just going to like give you the benefit of the doubt and say, oh, he seems like a nice person. Oh, he worked at this job for 10 years. We're going to generally believe him. It's actually the opposite. They're generally not going to believe you. So go in with that mindset as opposed to you think you're on a roll and everybody's picking up what you're putting down, because that's just not how it goes most of the time.
It's exactly the opposite. They will give the benefit of the doubt to the police.
Exactly.
Well beyond where you think it's, deserved or needed or anything like that. It's
yeah. And it's hard for people to understand that. And I get it because we all live our lives and think we know better. But Ian, thank you so much for joining me. He is doing recaps every day. What time do you do them usually? I know it's later, a little bit later on.
Usually 8:30 Eastern.
Okay.
I get a lot of people who say they watch yours and then yours tend to, and then so it's perfect timing for that. So
good. Yeah. 8:30 in-depth review, a lot of reactions. I've seen some clips from it that are really funny. Not that it's like a comedy show, but there are some that are just really funny. And
this trial has some moments like that. So thank you so much as well.
Absolutely. Yeah. And we'll link all of his social media pages, YouTube, Twitter, etc., in all of our description. So thank you for coming on. I'm going to have to come on yours. We're going to keep talking throughout this trial. I'm glad we were able to kind of jump in the middle, maybe closer to the end. We'll reconnect, talk through it some more, see how the defense's case in chief goes. But I value your opinion. I'm glad you came on. I'm happy we were able to talk through it. But that's all we got. So until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.